Honourable members, we are at clause 26.
Clause 26.
Honourable members, the question is that clause 26 stand part of the bill. The question is that clause 26 now stand part of the bill. Those in favour say aye.
Aye.
Those against say no. I think the ayes have it. Clause 26 now stands part of the bill.
Clause 27.
The question is that clause 27 stand part of the bill. Senator Mark?
Yes, Mr. Chairman, I know that the agency has the authority or is being given the authority to borrow money. It is one thing for the agency to borrow money. It's one thing for it to invest money. But I have a problem with the minister having the authority to lend money. I don't understand how a minister, this is not a susu, and I don't understand where the minister is getting involved.
Senator Mark, the issue that you have is, because it's a very short clause, with the minister having the ability to lend money. Yes? Attorney General?
Mr. Chairman, we're incorporating a body corporate. Therefore, the functionality of lending, borrowing, receiving, etc. must all be provided for. For the record, as Attorney General, the Office of the Attorney General handles the positive vetting of all arrangements for lending on a continuous basis. So this is a standard, normal feature, which is also articulating along with the Exchequer and Audit Act.
Okay. Honourable Senators, the question is that clause 27 now stand part of the bill. Those in favour say aye.
Aye.
Those against say no. I think the ayes have it. Clause 27 now stands part of the bill.
Clause 28.
The question is that clause 28 stand part of the bill. Senator Mark?
You see how we have collided in 28.
Brief comment, Senator Mark. Is there an issue with clause 28?
No. No, I am happy with it because I think what it is saying is exactly what I have said. That after the submit their report. Now this report, Mr. Chairman, is this the audited or is this the administrative report?
Attorney General?
Attorney General?
It is the annual report.
This is the annual report. Okay.
Honourable Senators, the question is that clause 28 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 28 now stands part of the bill.
Clause 29.
The question is that clause 29 stand part of the bill. Senator Mark, you have an amendment?
Yes, in clause 29, subsection 2, delete the word after in subsection 2.
I just couldn't follow where that deletion was supposed to come, if Senator Mark could assist me with that. Sums under subsection 1D shall be paid into the seized asset fund after the period A referred to under 43.3 has expired, or if I skip to B, within which an appeal may be.
Attorney General, the amendment here is really, we are saying that under subsection 2, after the word, let me just read it. Sums under subsection 1D shall be paid into the seized assets fund after any period rather than the period. That is the amendment that we have proposed.
So there are 4 these from the chapeau 1, A, 2, B, the 2 appearing. Which one is to be deleted?
No,
Subsection 2, Attorney General.
Yeah, there are four of them.
At the very end, before you get to subclause A. So sums under subsection 1D, following,
Yeah.
shall be paid into the seized assets fund after, and Senator Mark, delete
Any.
the word the, and put any.
We deleted that and we replaced it with any.
Attorney General, let me tell you, the policy behind that is that you had indicated in the in your piloting of the bill that one of the safeguards of this legislation is that you will only be anyone's property will only be subject to forfeiture after an appeal process has been finished. I thought that the way in which the section was drafted after the appeal has been determined, whichever is later, you have two concurrent levels of appellate jurisdiction in our courts, the Court of Appeal and the Privy Council. And I thought that the insertion of the word any after the appeal would capture not only the initial appeal to the Court of Appeal, but would also capture any subsequent appeal that may go to the Judicial Committee. So it doesn't take away anything from what you've, as a matter of policy, put into the legislation, but it will just make sure and capture the safeguard that it will only come to an end after the second, if that is triggered, the second appellate level.
I now understand the purpose is to take care of that second level. I'm just, with your leave, I'm just having a look at section 43, which is the compensation section.
There's mine? Yeah. Okay.
It would make sense insofar as 43.3 has both the High Court and the appellate routes. I agree to the amendment. Thank you, Senator Ramdeen.
Yeah, right. Much obliged.
Okay. Honorable Senators, the question is that Clause 29 be amended as circulated by Senator Mark. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Honorable Senators, the question is that Clause 29 as amended now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 29 as amended now stands part of the bill.
Clause 30.
Honorable Senators, the question is that Clause 30 stand part of the bill. Honorable Senators, the question is that Clause 30 now stand part of the bill. Those in favor say aye. Senator Mark? Very short. Senator Ramdeen, you have something to say.
I was just, AJ, I know at clause, I think it's clause 7.
Subsection 7?
No. At clause, I think at clause 7 is the section, you could correct me, where you have the, with, no, the interpretation, the provision for without notice, the, bona fide purchase of a value without notice.
Clause 7.9.
Should we not include that there in your lawfully obtained property? In addition to what you have?
Well, because so this interpretation subsection, clause 30, applies to this part, and property lawfully obtained is separated out from the different categories that we went. So we had looked at it as a standalone aspect. Recoverable property is caught by clause 7, and recoverable property with the exclusion of 7(9) for the bona fide purchaser for value without notice of the specified offense would stand alone. So, I mean, if it bites in one of our clauses looking a little bit later, could we perhaps look at it then?
I'm just wondering if you could ask the drafters if 7(9) would be a subset of one of these provisions. I'm just trying to see means.
We wanted to qualify 7(9) as to what recoverable property is, because when we're looking at the restriction orders in this part, and then we're looking to the conversion into a forfeiture order, we're only dealing with recoverable property. So we see it as standing alone and mutually exclusive.
But it's for someone who has obtained property as a bona fide purchaser for value without notice, would that person be captured by your property lawfully obtained?
That person would be captured by the fact that it is excluded as recoverable property. So that property would never fall into that net.
Okay, I just see, like you said, I agree with you. Can we just look at it as we go along?
I'm
see how it,
very happy to do that.
How it marries with
If there's a need to fine tune it, I welcome the approach.
Honourable Senators, the question is that clause 13 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 13 now stands part of the bill.
Clause 31.
The question is that clause 31 stand part of the bill. Senator Mark, you have amendments?
Yeah, Mr. Chairman, we are proposing that, consistent with the position that we outlined in the debate, that the Director of Public Prosecutions functions under law and the Constitution, ends at the level of criminal activity or charges, and we are mingling or co-mingling both civil with criminal, which is really unconstitutional as far as we are concerned. And therefore we are saying wherever we have the words DP, Director of Public Prosecutions, in this particular 31 2, we replace it with the word agency. And that is our amendment.
General?
Mr. Chair, this matter has been interpreted by several courts. We have had the experience coming out of Antigua and Barbuda and the United Kingdom, where the advocacy was pointed to say that civil and criminal ought to be two streams that don't mix. So we've had the benefit of judicial pronouncements that say that that is in fact something which can properly happen. It's also in the Canadian jurisprudence, as Senator Rambarat had pointed out in his debate. We don't think it proper for the agency to be advising itself, and we preferred to have the filter of the DPP. Section 90 of the Constitution, which gives the 3 aspects in which the DPP can operate: to initiate prosecution, to take over prosecution, and to end prosecution, are not the sole parameters which the DPP operates by or under. There are other parameters which we find in other pieces of law, statutes, which allow for a broadening and functionality. And then there's the common law that the DPP has by virtue of practice managed. Some of that is in the saved law aspect. Some of that changed in our 1976 Constitution in particular, when we brought in the creature function of the DPP away from the Attorney General as it stood in our constitutional arrangements. So for all of those reasons now on the record, we respectfully disagree with the invitation of the opposition to replace the DPP's functionality with the agency, and we ask Senator Mark to consider our position that way.
We are also proposing, Mr. Chairman, that we delete the words that there is insufficient evidence to pursue criminal charges for a specified offense, but that should be deleted. Because there's no need for that here.
1 second, AG. Senator Mark, you have also another one right below that. Could you just treat with the explanation for that one time as well so the AG can respond?
Yes, and we are also proposing that we delete the words "and an application should be made for recoverable property to be forfeited."
It's again the agency replacing DPP argument. Yeah? So, Mr. Chair, line item 6, line item 7, line item 9 on the list of circulated amendments of the opposition all deal with the central principle of the argument that they put, which is to say move the DPP because of the criminal stroke civil dichotomy which they have advanced as a submission. We don't agree with that submission because of jurisprudence in our own constitutional arrangements, both prior to the 76 Constitution, in our common law, and in our statutes, and we're comforted by the jurisprudence coming from elsewhere in the Commonwealth, which have said the opposite of the argument asked by the opposition. As it relates to line item 8, which is that there is insufficient evidence to pursue in 31 subclause 2, we see that as a safeguard, Mr. Chair, because we want to make sure, first of all, that the origination of these proceedings starts with a criminal investigation into a specified offense. They ought not to be fair in the hearts of people that they're exposed to any average policeman, even though it says Commissioner of Police, the Board of Inland Revenue, or the Customs, for a matter which is not a specified offense within the definition of that term in Section 2 of the Proceeds of Crime Act and as set out in the second schedule to the Proceeds of Crime Act. Secondly, we consider that the DPP must be engaged in this aspect, and it's only when the DPP says, look, I don't have enough to go for a full criminal run, in which case the DPP would have used the Proceeds of Crime Act itself, that the DPP then says to the agency, you may wish to seek civil aid to enforcement of criminal proceedings, because that's effectively what this is, and that's a concept which is well known in our laws and which is quite permissible, albeit under the functionalities of the Attorney General. It's at that point that the civil asset trustee steps in place of the Attorney General, being properly insulated from that function in the manner we set out here. So we think that this is an important safeguard to make sure people are not subjected to arbitrariness, and we prefer that it stay as a constant feature.
Senator Ramdeen.
Thank you, Mr. Chair. Honorable Attorney General, it was not an easy position to arrive at taking out the Director of Public Prosecutions from the proposed legislation, because there is a certain degree of comfort that people have with the independence and the insulation of the Director of Public Prosecution. But as a matter of practicality, I mean, you have indicated that you have to go before your assessment to pass your assessment with FATIF and CFATIF and all of these things. But let's just carve away at this for a minute. The Director of Public Prosecution, and I'm not saying this in any critical way, the Director of Public Prosecution is adding nothing to this process, because the only thing that he's doing is saying that he is not satisfied that he can pursue a criminal charge. But outside of that, we have a situation in this country where indictments are forwarded to the Director of Public Prosecution. There is nothing in this legislation, nothing can be put into it. It's not a criticism. There's nothing in this legislation that says where a report is forwarded under the Explain Your Wealth, right, civil asset recovery to the Director of Public Prosecution, he's going to give any priority to this. That's number one. So it comes to his desk like everything else. He has 1,000 murder PI indictments to deal with as we speak. You have indicated to us on the parliamentary floor, it takes 6 years for him to decide whether to commit somebody for murder or not. It takes even more than 6 years in cases where it's not a capital charge. My difficulty is this. we add this to his desk. And we expect that these things, because these things, the way in which this legislation is formulated, it has to be done with some degree of alacrity, right? You have provisional orders, just like you've explained, Anton Pilla and Moreva powers. So you have to be able to move with some degree of stealth in this kind of thing. You've also indicated to us that we have investigations that are going on in one case for more than 9 years. We must come to some position as to whether all of the work that we've undertaken as a parliament and given you as the Attorney General and the government the support for this legislation will not amount to naught if a very important investigation is done. The report is sent to the Director of Public Prosecution and you are waiting. And when I say you, I mean the agency is waiting for something to happen that doesn't happen for 5 years, and then by that...
Forgive me for interrupting, I caught it. Your simple submission is that this is to remove a potential roadblock for administrative capacity, and that you were perhaps comforted by the fact that the trustee was well insulated enough to make this decision. But if I may be permitted to distinguish the argument, this wasn't added to the DPP's desk, it was always on his desk. So because this specified offense under Proceeds of Crime Act was always on his desk, we were letting him say, well, look, I'm no longer keeping it on my desk because I haven't reached the bar and I'm sending it elsewhere. And that's where we take our departure.
Senator Vera.
Yes, I was seeing it the same way, that because what this section doesn't say, but it's implicit, where upon receipt of an investigative report under subsection 1, the Director of Public Prosecutions is of the view it could also be that he wants to pursue the matter criminally and then go for forfeiture in that case. But now he also has the option. Well, you know what? I don't think there's sufficient here to go for a secure criminal conviction, so let me refer it under the civil. So it makes sense. Now, I was troubled about this very literal circumscribing of the DPP's office within the Constitution. But I think it is important to have this section to counter that very concern that because he doesn't have that power statutorily provided, there was always open to the argument that he couldn't do it. We know he does it right now. He does a lot of things that are not narrowly contained as set out in the Constitution, but I think this makes it quite clear that he can make that referral.
Attorney General.
Spot on. I couldn't ask for a clearer description. Thank you.
Honourable Senators, the question is that Clause 31 be amended as circulated by Senator Mark. Those in favour say aye. Aye. Those against say no.
No.
I think the noes have it. Honourable Senators, the question is that Clause 31 now stand part of the bill. Those in favour say aye.
Aye.
Those against say no. I think the ayes have it. Clause 31 now stands part of the bill.
Clause 32.
Honourable Senators, the question is that Clause 32 stand part of the bill. Senator Mark.
Yeah, Mr. Chairman, we propose amendments to 32A, B, 32 subsection 2, 32 subsection 2A. In 32A, the word will, we would like to propose that it be replaced by the word may. In 32B, is be deleted, replaced by the word may. And 32 subsection 2, we insert after the words as soon as the words is reasonably practicable. And under 32 subsection 2A, we insert in after the word the company, the word being the subject of the property restriction order or a civil asset forfeiture order. We would like the Attorney General to consider.
Attorney General.
And before.
Let me explain why.
I got it, you know. I'm agreeable.
Okay, good.
Yeah?
Yep.
So, but there's perhaps a small bit of tidying up to do further in subclause E. So 32(1) subclause E. We should, so we take the word the as it appears in the first line, an equity valuation done for the company, we should say any company. And we agree that So any company which may be subject. So we agree that the will ought to change to may. We should change the in the first line to any. And then the O, as it appears, be subject to an order. That really ought to be a capital O. And we agree to the recommendation that is to be, it should be instead may. That's in B. So I don't know if Senator Mark is willing to adopt those recommendations.
Yeah, no problem.
Yeah, sub 2.
So then, Senator Mark, in light of what the Attorney General just said, are you willing to withdraw your amendments to clause 32 so that the amendments as put forward by the Attorney General?
Chair, we just have to do sub 2. We could do all at the same
Oh,
time.
we have several amendments to sub 2.
We did sub 1.
To 32.
Treated with A and B.
Yes.
You spoke to 32 subclause 2 and 32 subclause 2, further subclause A.
Yeah, but the Attorney General would like to inquire
Attorney
into those
General,
things further.
would you like to respond to clause 32 subclause 2 and clause 32 subclause 2A?
Right, so just let me get it into context here. 32.2, insert afterwards, as soon as. As soon as possible.
You have them in.
Yeah, as soon as is reasonably practicable. So line 12 really should be that you're deleting the word possible because it's not stated there, right? And then inserting instead is reasonably practicable. Yeah. Agreed?
Agreed.
So delete the word possible
Yeah.
and replace with reasonably practicable. Is reasonably practicable.
And you could do your same surgery to A and take out the and put any.
Yeah.
Which is what you did before.
An equity valuation done for
Any company being the subject of the order, because by that time this presumes this is second limb, so this presumes the order is made. Because this is after.
So insert after the words as soon as the words.
Yeah, we can do that. After the word company, which may be subject.
No, don't put which AG, because this is after the order. So this is after the order has actually been made. Yeah, so it has to be being.
I was just wondering if the chapeau caught it, which is why I'm sort of hesitating. Huh?
No, because if you
yeah, I catch you.
Yeah.
Being the subject.
Yeah, because if you look 4 lines down right-hand side, after the property restriction order or civil asset forfeiture order is made.
So, after the word company, being the subject of an order under this part, or the order that was made. So the order, right? Being subject of the order, right? So, Mr. Chair, if I could just assist in the texting of subclause 2. In subclause 2 at page 26, this is 32 subclause 2. At the 4th line, where the words shall as soon as, delete the word possible and replace with is reasonably practicable.
Okay.
Then in subclause A, that is 2 subclause A, at the last line of the sentence, yeah. So we can, forgive me, let's go to A. An equity valuation, delete the word done, because it appears in the chapeau. So an equity valuation for the company, change the to any, So an equity valuation for any company to accurately determine the debt load and equity of, it would be the.
Yeah, it would be the is fine.
Subject of the order.
Right? And then at the end of the word company, we add the following words. This is in A, being the subject of the order. So, here. Yeah. Fortunately, Mr. Chair, we have the presence of the Chief Parliamentary Counsel himself, who is by far a better linguist and drafter than any of us here. And he's recommending that instead of taking those last words at the end, he's recommending that it comes after the word company. So it'll read like this. And I read A, subclause A, an equity valuation for any company being the subject of the order to accurately determine the debt load and equity of the company.
So delete that
H.
and at the very end of that.
No, that has to remain.
And then
Right.
AG, can I make another suggestion?
we probably have some surgery to B as well to do. Yeah.
Yeah, that's what I'm going to tell you. In B, it should read evaluation of any other asset which is.
We're on the same
Take
page.
out to B.
Yeah. Which is. So, and in B, Mr. Chair? Yeah, it should read evaluation of any other asset which is, delete the words to be. And that should take care of it.
Mark, in light of what the Attorney General has just said, are you willing to withdraw the amendments that you have circulated?
Yes, because the
So
AG,
withdraw.
the AG's amendment actually.
Thanks, Senator Mark, for raising the amendments which we have incorporated.
So, honorable senators, again, as before, I would ask that everyone follow on page 25 as I go slowly with the proposed amendments to clause 32. So the question is that clause 32 be amended as follows. Subclause 1, A, delete the word the, insert the word any. After the word which, delete the word will, insert the word may. After the word and, capitalize the word o in order. At subclause B, delete the words after which is to, insert the word may. At subclause 2, delete the word possible, which comes after as soon as, and insert the word is reasonably practicable. At further subclause A, delete the word done. Delete the word the, which comes after for. Insert the word any. After the word company, insert the words being the subject of the order. And further subclause B, delete the words to be. Attorney General,
That's perfectly correct.
those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Honorable Senators, the question is that clause 32, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 32, as amended, now stands part of the bill.
Clause 33.
Honorable Senators, the question is that clause 33 stand part of the bill. Senator Mark.
Mr. Chairman, we have proposed
And the AG, yes.
a number of amendments to clause 33 for the Attorney General's consideration. In 33.1, we are proposing we delete the words by the Director of Public Prosecutions. In 33(2), we are saying that we delete that completely. In 33(3)(b), we are also proposing that that be deleted completely, because we are clear that this is civil and not criminal, but we are also clear that it is criminal too. But just for clarity, we think it's better we delete that completely. And we are also proposing, rather, in 33(5), that we remove the number 2, because we have just deleted that. And we are also proposing that we delete the words "and without notice."
Attorney General?
I understand the consistency of the opposition's approach on the issue of the DPP, which ground I think we have already traversed, and we have a difference of policy positions on that. So I respectfully decline the invitation to delete the references to the Director of Public Prosecutions. With respect to the term criminal conduct, that is defined in the context of this bill, and that is to be found at page 3 of the bill, where the definition of criminal conduct is specifically that which is a specified offense both within and without Trinidad and Tobago in the context of that description. We therefore respectfully can't agree to the amendments of line 15, line 16, and line 17 as proposed by Senator Mark. With respect to the deletion of "and without notice," if subclause 5 were to be done ex parte and without notice, we think that we'd be doing an injustice to the fact that, first of all, that this is something that may be done. It is not mandatory. There's nothing to stop a judge from saying, we want you to actually serve the ex parte opposed, as it's done. It's an ex parte opposed, where you give counsel the right to actually hear. But it is to preserve the ability that in instances where the assets may be frittered or lost in typical Mariva type situations, that you preserve the right to move ex parte and without notice. In our own discussion of Section 33, Mr. Chair, we had noticed an inconsistency in our approach in subclause 4, because we had inadvertently confined ourselves only to the policeman as the part contemplates, when in fact it is the customs officer, the police officer within the particular rank, and also the controller. So the chairman of the Board of Inland Revenue, the controller of customs, as investigating officers, must go alongside the police officer as defined. So we had proposed the deletion of the word officer, and then the understanding of what the investigating officer would be the 3 people referred to earlier. We're deleting the word police, yes, forgive me. So it's not just a police officer. It's any officer being of the 3 species.
Senator Ramdeed.
Yeah. With respect to 5, with the subclause 5, you said an application under subsection 1 or 2 may be made ex parte and without notice. But being it being made ex parte is without notice. It will preserve the position of you going to in a position where you don't want the other side to know.
Well, the usual formula is ex parte and without notice. So we've seen it in both ways. You can say ex parte and then say that it also implies without notice. It's a sequential thought, I agree. However, we wanted to make sure that we were expressed on the positions, because there's been litigation about this. Ex parte opposed, for instance, is technically without notice but opposed.
But that'll only be if the judge thinks so.
Correct. Which is why we use the word "me."
Yeah, but I have a problem with one thing that is not covered by the amendments, which is this. Under Section 33(1), we accept your position. Well, you have hold firm to the policy position of the DPP being in. So let's take that for granted. Upon referral of a matter by the DPP under Section 31, the agency shall apply to the High Court in the prescribed form. But we're not setting any time frame for them to do it. when I'm saying, if you don't want to put a days, meaning like within 14 days or 28 days or whatever, but at least they should be doing it with some kind of alacrity, because this is for a provisional order.
Well,
should we not say as soon as reasonably practicable?
then that would open a whole Pandora's box into judicially reviewing the time frame within which they were to act, and therefore put some form of prescriptive consideration into the mix. So we didn't want, in the difficulties and with the vicissitudes of prosecutorial action, to put in a time frame on that end. They would be chasing, for instance, in summary offences, a statutory time clock anyway, obviously not the same for indictable offences. So we preferred to leave it that way. We do think that in subclause 5, we could delete the words or and then in number 2, because the reference to or to don't necessarily make sense in the body there. So we would add to our deletion of the word police in subclause 4, a deletion of the words or and the number 2 in brackets in subclause 5.
You see, the problem with it is this, Adrian. If under the Interpretation Act, they will still be required to do it as soon as is reasonably practicable. So the same Pandora's box of being able to do it, because where they have an obligation to apply to the High Court, because the problem with this is that if you keep the word shall, it means that they have to do it. So there's no discretion. So if they have to apply to the High Court upon the referral under the Interpretation Act, they will have to do it within a reasonable time anyway. And
the civil proceedings rules will amplify that, and also the discharge on grounds of delay and abuse would also feed into that as well. So putting it in the positive point that they must provides adequate safeguards for people to say, well, look, your undue delay in your disposition, etc., and you ought not to prosper.
Senator Vera?
Yeah, I understand Senator Ramdeen's point, but when you are looking to go for any kind of, whether it's Mariva, Anton Pillar, or as a prosecutor, you always have to have one eye on timing and logistics. And putting in arbitrary timelines could be counterproductive. Take, for example, you may go to court today, but it's a long weekend, and you can't get anybody at the bank to freeze your account so to do something. That's one instance. But you also have to get your people in place. So I think this is probably a better way to leave it open.
And the Rules Committee of the court really come up with the prescriptive remedies for these things. I mean, if we look to the revisions of the civil proceedings rules in particular, and the manner in which we have done some surgery to timelines and filings, etc., and then that whole spawning of what was once the massive disaster of Trincan until Matthews came along, we really see the subsidiary rules taking care of these prescriptions.
Honourable Senators, the question is that clause 33? The question is that clause 33 be amended as circulated by Senator Mark. Those in favour say aye.
Aye.
Those against say no.
No.
I think the noes have it. Honourable Senators, the question is that clause 33 be amended as circulated by the Attorney General and further amended at subclause 5 to delete the words or and 2 in brackets. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Honourable Senators, the question is that clause 33, as amended, now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 33, as amended, now stands part of the bill.
Clause 34.
Honourable Senators, the question is that clause 34 stand part of the bill. Senator Mark?
Yeah, Mr. Chairman, we are proposing that in clause 34(1), delete the words alleged to be. We are also, and replace it with the words of which there are reasonable grounds to suspect. As the first proposed amendment we are suggesting, we are also proposing in 34(5), subsection C, that we delete the words delete the word sees fit and replace with the words it considers appropriate. And in 34(9), we are proposing that we delete the words is limited in A, that is we delete the words is limited to reasonable legal expenses that the person has reasonably incurred or that the person reasonably incurs. And we are also proposing that we insert in B includes any other matter the High Court sees just in the circumstances. Those are the amendments that we are proposing to clause 34(1)B, clause 34(5)C, and clause 34.
Attorney General.
Sub 9.
Thanks, Senator Mark, for the proposals. The first aspect in 34 is 34(1)B. There is a definition of what associated property is to be found in section clause 3. It's the first appearing, second appearing at page 2 of the bill. Associated property means in relation to criminal property, terrorist property, or instrumentalities of crime that is recoverable under this act, that part of the property which is not recoverable, and A to D are then included. So the context of usage of associated property in subclause B is to be factored firstly by reference to the definition. We say in B, the property to which the application for which the order relates includes property alleged to be associated property, and the agency has not established the identity of the person who holds it. We've used the concept of alleged to be because there is no one to defend its status. And so even though we understand that there could be some concern about an allegation for a thing which is defined, it was in the circumstance of the fact that there was no one there to defend the information which would make it certainly associated property or something else. The second reference to subsection 5C makes such other orders as it sees fit. There is no objection to considers appropriate. They capture the same sort of essence to that. If that were to give some comfort, we could easily treat with that by agreeing to it. So considers appropriate. If we then turn to subsection 9, subsection 9 says, where the High Court provides in a property restriction order for a person to meet legal expenses that the person has incurred or may incur in respect of proceedings under this part, the High Court shall ensure that the provision A is limited to reasonable legal expenses that the person has reasonably incurred or that the person reasonably incurs, and B specifies the total amount that may be released for legal expenses in pursuance of the exclusion. The recommendation coming to us is any other matter the High Court effectively sees fair. So if I could just try and look at the recommendation at line 21, the proposal is to delete subparagraph A, the limitation of legal expenses, and B would be includes any other matter the High Court sees just in the circumstances. When we looked at this and we looked to the Cayman Islands, we looked to British Virgin Islands, we looked to other positions and the Commonwealth model, and we looked to the Anti-Terrorism Act where we did the carve-out for legal expenses, and we looked to the usual qualifications for Mariva injunctions where the exceptions for that which is frozen apply, we felt it prudent to tell the court that the court must be satisfied that there are reasonable expenses and that they must be reasonably incurred, because there can easily be an abuse in respect of legal fees.
Mr. Chair, through you, we understood that to be the policy. The reason why we had asked for the amendment to be made, because if you go back to sub 8,
Yeah.
right, you would see that the powers of the court are circumscribed by
Indeed.
only making provisions for reasonable legal expenses.
Yeah, but 9 is where we grounded the positive obligation to demonstrate it, to say that the court must be satisfied. It must ensure. So we wanted to put that extra caution, because the literature that comes in particular for the carve-outs for anti-terrorism, legal expenses and other positions, the literature which has come back to us in many forms, is that you really ought to take care to specify these two things: reasonable expenses and that they're reasonably incurred, because it can form a method of abuse. And even though I belong to that class of, and that profession, our profession of attorneys at law are not known in some circumstances for reasonableness, especially as it relates to legal fees.
Okay, so Attorney, Senator Hussain.
Thank you very much, Chair. AGM, I have a little trouble with respect to subclause 1, which is really the heart of this section in terms of the test in which an applicant has to satisfy before an order is made. Now, I'm comfortable with sub A, 1E. But when you go down to sub B, I think that the threshold is too low with respect to the property just being alleged to be associated property.
Just press the blue.
Now, with it being alleged, it's even below the standard, the evidential standard of that of suspicion. I mean, there's no harm in accepting the recommendation that the property, there must be some, if I had my way, I would have said reasonable grounds to believe, because it's property rights we're interfering with at the end of the day. But reasonable suspicion is probably a better standard in order to protect the property rights of an individual here. So instead of alleged, I think we should go with the reasonable suspicion standard. Because sub A gives a higher standard, which is reasonable grounds to believe.
Yeah, I think it's a very sensible submission. So we would happily accept it.
Okay, so Attorney General, just to treat with procedure. So that is, you're removing, could you walk me through it, for
Yes.
the amendment that just...
Did you get it? He said okay?
In the meantime, Senator Mark, in relation to the amendments you propose on clause 34, are you... Yes, clause 34 5C was the one that the Attorney General indicated was agreeable. Clause 34 1B and clause 34 9 were the ones that there was a difference of opinion on.
To suspect
Would
is.
you
Yeah.
like me to still put the question in relation to all three?
No, I think he's still considering. B. So, yeah, I think he's considering.
Okay,
so
I'll wait for the Attorney General.
Yeah, let him, let's see what his position is.
Mr. Chair, in 34(1)(b), it may, I accept Senator Hussain's recommendation that we move from the alleged to be formula, and it would read, in terms of a proposed amendment, that after the word property, as it appears in the second line of subclause B, 34(1)(b), we would insert the following words: of which there are reasonable grounds to suspect is associated property. Right? So we delete the words alleged to be. So subclause B would read, the property to which the application for the order relates includes property of which there are reasonable grounds to suspect is associated property. Right? And then in subclause 5C, which appears on clause page 28, we delete the words sees fit and insert the words considers appropriate. We respectfully, for the reasons volunteered in subclause 9, have some difficulty with the recommendations offered by the opposition. And so those are the amendments that we consider are appropriate. B. So in subclause B, 9B, 9B to add the any other matter the court sees fit. Yeah? So if we went to 9B, specifies the total amount that may be released for legal expenses in pursuance of the exclusion, the recommendation coming is includes any other matter the High Court sees just in the circumstances.
Sorry.
33.
Page 33. 35.
Yeah. I see.
35, 5.
C.
C.
Yeah. So a new subclause C
Yeah.
would be appropriate for consistency, which would read, Mr. Chair, so at the end of B, after the semicolon, you put a semicolon, or, sorry, and, yeah, and, you see. So forgive me, at A, after the word, after the semicolon, delete the word and. B, where the full stop appears, delete and put a semicolon, and insert the word and then put a C, which would read, includes any other matter the High Court sees just in the circumstances. Oh, well, we can say considers just. Considers appropriate. What is the word we had used?
Just use the same ones that you have at
Yeah.
page 33, so be consistent.
I know, but we had just changed the 9. We had done the other one to say considers just. Yeah? Any other matter the High Court considers appropriate
In these circumstances?
in the circumstances.
Yeah.
In the light of the response by the Attorney General, are you inclined to withdraw your amendments?
I think the Attorney General has agreed except for
9A.
except for 34(9).
Yeah,
A.
Okay.
yeah.
So
is it
so
withdrawn?
I withdraw that, sir.
Honorable Senators, once again, follow along at clause 34. I will go as slowly as possible so that members can follow. The question is that clause 34 be amended as follows. Subsection 1, subclause 1, sorry, further subclause B, delete after the word property, insert the words of which there are reasonable grounds to suspect is, delete the words alleged to be. At subclause 5, further subclause C, delete the words sees fit and insert the words considers appropriate. And at subclause 9, further subclause A, after the semicolon, delete the word and at subclause B, delete the full stop after exclusion, insert a semicolon, insert the word and, insert a new subclause C with the words any other matter the High Court considers appropriate in the circumstances.
That's it?
Those in favor say aye.
Aye.
Those against say no. I think the ayes have it.
Just for the record, I know you said it, it's includes any, right? So C, the new C, the first word appearing is includes any.
Oh, includes.
Yes, please.
Okay, so let me just reread that last part. At subclause 9, further subclause C, new subclause C includes any other matter the High Court considers appropriate in the circumstances, correct?
Yes, sir.
Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Honorable Senators, the question is that clause 34 as amended now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 34 as amended now stands part of the bill.
Clause 35.
Honorable Senators, the question is that clause 35 stands part of the bill.
Yeah, Mr. Chairman, we are proposing for the consideration of the Honorable Attorney General that we delete in 35(5)(a) the words is limited to reasonable legal expenses that a person has reasonably incurred or that a person reasonably incurs. And then we are also proposing in clause 35(6)(b), and this is consistent, AG, with the CPR or the civil proceeding rules. Delete the word leave and insert the word permission. So I just want to ask you to be consistent with the CPR rules or the CPR.
Attorney General.
If I start from the top, 35, I thank Senator Mark for the recommendations. I recognize that the proposed amendment in respect of subclause 5 is anchored in the logic of the clause 34 that we just considered, and I respectfully ask that we maintain the language as it is. I do think, however, consistent with the amendments offered to subclause C, that we should change the words "sees just" in subclause C and replace with "considers appropriate." And we have no objection to the word permission by deleting the word leave in 6B and replacing with the word permission.
Second line.
In sub B,
6 sub B, which the
no
order
distress
applies.
may be levied against property to which the order. Is it an order under this part or this common O? No distress may be levied against the property to which the. I think it may be capital, you know. Yeah, I think it would be.
Definition of this?
Property restriction order,
Yeah.
capital O, 35(1).
Reasonable living.
Then we say it in 3, we say it in 2, we say it in 3, 4. Then we deal with the exclusion. The High Court makes an order under this section. And while the order is in effect, the High Court may stay any action. So question that first order in 6, in the chapeau. Forgive me, Mr. Chair, one moment.
Sure.
I thank Senator Hussain for the inquiry. It is, it's properly a common O because it's an order under this section as opposed to the property restriction order. Yeah, but thanks for the clarification.
General, I will put the question to the first amendment that Senator Mark circulated. He has 2 on 35. And then you had a further amendment in relation to 35 subclause 5, further subclause C. The question is that clause 35 subclause 5, further subclause A, be amended as circulated by Senator Mark. Those in favor say aye. Aye. Those against say no.
No.
I think the noes have it. The question is that clause 35 subclause 6, further subclause B, be amended as circulated by Senator Mark. Those in favor say aye. Aye. Those against say no.
No. Well, you see, what I'm confused about, what would be tidier is if we took the clauses themselves, asked which was withdrawn in light of the positions, because the government has made amendments, and therefore we could have taken it in one go. But I didn't want to interrupt your flow. I thought you were going to put ours after.
I'm going to put yours after. What has happened here is that one amendment to clause 35 put forward by Senator Mark is not agreed upon. The second one is. So I'm trying to dispense with the amendments as proposed by Senator Mark and then treat with the amendments as put forward by your good self. Okay. The amendments as put forward by your good self, within that, one that has been proposed by Senator Mark is agreed upon here. So it's either Senator Mark withdraws in entirety his amendments to clause 35, and then I put the amendments in its entirety as put forward by you, the Attorney General, which was inclusive of the second one of Senator Mark.
Sure, as you please.
Senator Mark?
Mr. Chair, if I understand what you're saying, there is some disagreement as it relates to 35(5)(a).
That's right.
So I can withdraw that.
Okay.
The other one, I think that the AG would be willing to accept, because he did indicate that he has no problem with that.
Right. So as which is exactly what I just did. What I just did.
Well, you see, I think he wanted us to clear this one first. So
that's
now
fine.
we have cleared that.
That's fine. I'm still going to put the question on the one clause that clause 35, that your proposed amendments to that is agreeable. The Attorney General also has an amendment to clause 35, which I'm also going to put subsequent to. So again, I'm putting the question.
No.
Honorable Senators, the question is that clause 35, 6B, as circulated by Senator Mark, be amended as circulated by Senator Mark. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Honorable Senators, the question is... Honorable Senators, the question is that clause 35, 5C be amended as follows. Delete the words "sees just" and include the words or insert the words "considers appropriate." Attorney General?
Yes, sir.
Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Honorable Senators, the question is that clause 35 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 35 as amended now stands part of the bill.
Clause 36.
Honorable Senators, the question is that clause 36 stand part of the bill. Honorable Senators, the question is that clause 36 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 36 now stands part of the bill.
Clause 37.
Honorable Senators, the question is that clause 37 stand part of the bill. Honorable Senators, the question is that clause 37 Senator Mark, we must move on. Honorable Senators, the question is that Clause 37 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 37 now stands part of the bill.
Clause 38.
Honorable Senators, the question is that Clause 38 stand part of the bill. Senator Mark?
Yeah, Mr. Chairman, we are proposing in 38 sub 5 that we insert after the words 28 days, the words from the date of seizure. That's the first amendment that we are proposing. And 26, yeah, but in 30.
Senator Mark, are you ready to explain your proposed?
Okay, yes, yes, oh, this is a new. Oh. Yes, sir. Yeah, Mr. Chairman, we are saying that this clause reads that property seized under an order granted under subsection 2B may be retained by or on behalf of the agency for 28 days. And then it just goes on. And the agency may subsequently make the application for a property restriction order. And what we are saying is that we want to make it very clear that 28 days after, or from the date rather, of the seizure, so that at least it could be made very clear. We'd like the Attorney General to consider including those words.
I'll take Senator Vera's comments in the meantime. Senator Vera?
Yeah, I support that, that recommendation because it is really the agency, and the agency may get an order today but not actually seize the property 14, 15 days afterwards, and the clock should start really ticking from when the agency is possessed of the property. So I think it's an eminent suggestion.
So, Mr. Chair, the way I read the section is in the reverse, right? Property seized under an order. So the issuance of the order is not a seizure until it's actually possessed. So I had understood it quite properly to mean that the order had to be enforced. So a writ of FIFA, for instance, or an enforcement order in the old days, the issuance of the writ doesn't mean that you actually have the enforcement. You have to then engage in the exercise of levy, take possession, all the common law rules as to how that happens. You hold on to it, you put a notice, all of those things came in. However, if it was a simple matter of avoidance of doubt, I mean, the language won't hurt. So it may actually go to enlarge the time frame from that perspective. So we can insert it after the words 28 days from the date of seizure.
So it is 28 days from the day of seizure. From the date of seizure.
Chair, I'm not sure what that adds to anything in this particular clause. The addition, I'm not seeing what it adds. I don't see any.
Respond.
Okay.
Whether they accept this new subclause 6.
Mr. Chair, as I said in response to Senator Vera, I could never contemplate that a seizure would be effective upon the issuance of the order. A seizure is only on the enforcement of the order. So the execution. So I never understood that it could be anything but what the language says here. However, and I'll say it openly, insofar as it may give me an enlargement of time out of an abundance of caution, which is on the side of law enforcement, I'll take it for what it's worth. I do prefer the language in its original form, but I can see the merit, as offered by Senator Vera, of putting in the qualification.
Okay, Attorney General, could you just
So, Mr. Chair,
clarification?
the proposed amendment to clause 38 will be at subsection 5, which is at page 35, after the word days, as it appears at the third line, insert the following words, from the date of seizure.
Okay. That is it? Okay, Senator Mark, on your proposed amendment, I'm seeing here 38.6, new clause.
Yeah, that's a new clause that we are proposing at the end.
So this is a new, so this what you have written here is a new clause.
Yeah, that comes after what we are dealing with.
Right. So, Attorney General, in light of what you've just proposed, do you want to respond to what is being proposed here?
Well, I think that new clause is only after we complete everything, so.
Well, I understand it's a new subclause, so that it could be taken at this point.
Oh, yeah, okay, yeah. All right, yeah, Attorney General? I think that, Mr. Chairman, if I may, I think everyone agreed here that once you seize the property and the order falls through, then the property should immediately be returned to the person from who it was seized forthwith, and not have the person go on I think everybody has agreed to that we shouldn't have to go and reapply for our own property. When it says, let's say everybody.
Mr. Chair, my difficulty with this, I understand the mischief that is intended, but it doesn't take into account all of the other procedures which may apply. There's a route of appeal, there may be a further order, there are ongoing processes inside of this. And I mean, it's axiomatic that property that is no longer under seizure would have to be returned. And
Just interrupt and give you the perfect example.
If I could just finish it.
Sure, sure.
So I was going to say, it's axiomatic that it has to be returned. However, there has been a practice of causing it to be returned, and whether there's a positive step to be taken. Now, the state, in the instance, is being invited to take the step to return forthwith. But that assumes that the state is as nimble as the individual, which is never the case. So even though we find ourselves in this position of asking the applicant, the respondent in this instance, to take the step if it is that it's not returned, I think that bearing in mind the difficulties in the state's operation, that it would be unduly onerous to put the state in that position of not returning. If I get the return factors as well, do I give constructive possession? Do I give actual possession? Suppose it has been locked away in a position. There are all sorts of ramifications as to the delivery of possession, constructively or actively, that cause me some concern now. So I think that these things could be managed by way of the subsidiary legislation and rules. But to jump to saying that we will, where no application is made by the agency under 38.8 within 28 days from the date of seizure, the property shall be returned to the person from whom it was seized. There may be an impracticality in this.
Senator Vera?
AG, I understand what you're saying, but we are talking about the deprivation of property, constitutionally enshrined guaranteed rights. We're talking about it being done by due process. What this is kicking in here is an application. You either make your application so that people know that you mean business and you're serious, or you're not. We have to think from the point of view of a person who is a victim here. You know?
I'm just going to do a quick comparison across the Proceeds of Crime Act. I know search and seizure comes about at somewhere around Section 32.
You may be out of your home, you may be out of your business.
But you're not out of due process, is my point. I know you recognize that when you said that a little while ago. Yes?
I'm sorry to disturb you, but why do you say you're not out of due process?
Because you're still within the point of being able to compel the return, taking the step to say positively, look, this order has expired, please have it returned. So, I mean, my question is...
You mean, I just want to have the conversation. You mean that the property is not they've not made an application. They've seized, they've not made an application. The property now, at that point in time, there's no justification for holding the property anymore. Are you suggesting that the person whose property is the subject of the order should make an application for it to be returned?
So what we're talking about is the trigger to cause the return, because once the order expires, it's not held from a legal point of view, it may be practically being held. And it's the mechanism of delivering out of the state that we're talking about. The positive obligation, the positive obligation that we're putting on the state right now is to do something within a specific period. Wearing the hat of the state now, I'm just concerned to understand the realities of the state doing it in a measured way.
Can I give you another side of the coin, which is this? The property, the 28 days has passed. The property is not returned. In law, there's no justification for the property to be returned. Sorry, for the property to continue to be held by the state.
And you're subjected to detinue.
Yeah, well, the subject to detinue is one thing. That's one aspect of the liability. Yeah. But then you're going to saddle the state with the liability, with the same argument that is being made, of having to pay the cost of proceedings that are going to be instituted for the return of the property, which is something that we should really be trying to prevent, because at the end of the day, I don't think, and I don't say this with any criticism, but I don't think that we should. And the example I was going to give when you were making your contribution was this: we have examples in this country right now where exhibits, and you had made reference, there's some aspect to this thing that deals with exhibits. There are cases before the courts where exhibits are held by the court for 8 and 9 years when there's no reason to be holding them. And the reason why that is so is because there is no provision in the law that compels them to have to return it as soon as it's finished.
I've gone to the Proceeds of Crime Act, and I'm looking specifically at Section 31, 32. Orders to make material available for investigating the benefit from a specified offense. And this falls under... And here's what subsection 5 says. The period to be specified in an order under subsection 2 or 3 shall be 7 days unless it appears to the judge that a longer or shorter period would be appropriate in the particular circumstances of the application. So there's a trigger here for an application. Purposes of an investigation, if an application is... So I'm looking at, yeah, so I'm not in pari materia.
No, I'm sorry.
Right? So I'm looking at subclause 5 of section 32, albeit it is not in pari materia, it's in the reverse, right? It's where there's a discretion as to what the time frame for return looks like. Because I have to measure here now what the practicability of return is. If it was a ship, if it was a vehicle if it's somewhere else. I don't know if there's a mandatory position of 28 days meeting the circumstances. So I'm looking for some sort of formula right now that says, as soon as it's reasonably practicable in the circumstances, because I can't anticipate what the circumstances of reasonableness would be just by reference to 28 days. That's the mischief that I'm trying to wrestle with now. Any thoughts on that, Senator Vera?
This is a police officer who finds something that he thinks is recoverable property and seized. I mean,
No, not.
if there's going to be a...
Take it a step further. The police officer goes to the agency. The agency does the seizure. The seizure is then put into the hands of the property manager. So it's not the police officer, just to be clear.
Oh, well, you're reinforcing my point then.
Yeah,
Because
so I'm now about
you
the
have to be
delivery out.
responsible.
I'm dealing with the mischief of detinue applying after a certain prescriptive period. If I seize a yacht, and the yacht for the asset manager says that it is delivered in some safekeeping in St. Martin, the 28 days may become problematic. So I'm looking at the issues of constructive delivery versus actual delivery. And what would be prudent in these circumstances is really if a court were to say what is practical in the delivery out, but to put a one-size-fits-all is the mischief that I'm on right now.
But that same yacht that may be delivered in St. Martin, look at it from the owner's point of view. He may have a charter yacht business. He stands to lose on the deal. He can be in all kinds of difficult situations because on belief. One would think that in a situation where you have moved the court, you have enough confidence in your case to move due process along swiftly.
The case and the seizure are related, but also not related. So the question is the practicability of the asset trustee delivering the item out. When you stand in the shoes of the state and you have to pay damages, it becomes a very real thing. So it isn't a capricious act that I can just simply say, not that I don't mean to be pejorative, right? I want to caution against a one-size-fits-all. The recommendation here is that within 28 days from the date of seizure, where no application is made, within 28 days from the date of seizure of the property, the seized item shall be returned to the person from whom it was seized forthwith. My problem is the forthwith.
Maybe we can move it from 28 days and expand it, but...
No, I have no problem with making the application. You want to continue the detenue, well, I shouldn't say detenue. You want to continue the detention or seizure, go and apply it to the court.
Yes.
It feeds in from the subsequent point that we have later. It's the forthwith.
Senator Mark.
Yeah, AJ, our subclause does not talk or refer to any new application. We are saying that the state, through its various, where here how it reads, so that where no application is made by the agency under section 38(8 within 28 days from the date of seizure, the property seized shall be returned to the person from whom it was seized forthwith. So if you fail to make an application within 28 days, you're depriving me of my property for 28 days.
Senator Mark, I'm not on that, if I may interrupt.
Okay.
So it should be subsection 5, right, and not 8. It's not 38(8), it's 38(5).
Okay.
38(5) says property seized under an order granted under subsection 2B may be retained by or on behalf of the agency for 28 days.
Right.
From the date of seizure, we've now put in. And the agency may subsequently make an application for a property restriction order in respect of the recoverable property. Right. So insofar as it's a subsequent to the expiry of 28 days, the new proposed 38(6) is slightly askew, right? So, because it implies that there's a time frame between the expiry of the order and the making of a fresh order. So, what what happens is 38.6 can be read in two ways. Because we left the word subsequent in 5, right? So effectively the mischief that I understand, Senator Vera, tell me if I'm getting you wrong, is twofold. One, you've seized it already under 38.5. Two, you have a further opportunity to apply for the renewal of that if you wish, which is reasonable in all the circumstances. If you don't apply for the renewal, then you should return the thing, because it's only a further order of detention that the court should have to separate the thing from where it ought to be. In those circumstances, the sole mischief that I have here now is the word forthwith. So as soon as it's reasonably practicable, makes sense in the matrix, because then that factors all of the vicissitudes of the type of property that we're talking about in the circumstances of ordered detention. So if forthwith were to go to...
Just to put on the record, AG, that we understand that you're representing the state and that's the cap you wear, but we also have a duty, a responsibility to the citizens and their rights and freedoms and entitlements. And so the concern is striking that right balance.
Agreed.
You see, you probably will forthwith. When you take a man's property, his property rights. Yeah, property rights. Tony, Anthony, what time frame? We said forthwith. He's saying that is true.
No, I agree. That is my sentiment and my feeling from the but I don't know. It's true. But let's see, because you could also soften and say forthwith and in any event not later than, and put in a time frame. So that could be a compromise. But the state should not be a big bully. The state has to respect the rights of citizens.
Exactly. Exactly. I still forthwith. You want to take my property? And you make an application.
The other point is this, remember you have a run up to this, you had to do your research and things before. Why have they given you 28 days? It's not when you receive the property the first time you're going to start this process?
Yes, exactly.
38.5.
So, Mr. Chair, if a new subclause 38.6 were to be read this way, where no application is made by the agency within 7 days of the expiration of an order under subsection 38.5, under subsection 5, right? Within 28 days from the date of the seizure of the property. No. That'll come out. The property seized shall be returned to the person from whom it was seized as soon as is reasonably practicable. And in fact, that should at least be 14 days and not 7.
I would prefer shall be returned forthwith and at any event not later than 14 days.
My difficulty with the forthwith is that we are talking about multiple species of property that we cannot yet contemplate.
Attorney General, I think you've made that point over and over again, and there's been some discussion, lengthy as it is, in relation to that particular word. The Attorney General has indicated that he does have some trepidation in relation to the word forthwith. He is currently drafting a new subclause 6 to clause 38, which I'll ask you to just read in its entirety shortly, Attorney General, so that we can have that written down for when I put the question. So could you just, as soon as you're done, read it in its entirety so we may have that?
There may in fact be a fair compromise to Senator Vera as follows. where no application is made by the agency within 14 days of the expiration of an order.
Hold on. Within 14 days.
Can I interrupt you?
The expiration of an order.
Under subsection 5,
Under subsection 5,
the property seized
the property seized
shall be returned to the person from whom it was seized
from whom it was seized
within 14 days thereafter, or as soon as is reasonably practicable.
No, that doesn't make sense.
To take care of the different species of property, because the state cannot at this point agree to 14 days. We will be in default and subjected to positions.
Okay, so
But I want to just ask a question.
very short.
Yeah,
Very short.
No, it's just because that changed.
Very short.
In the draft that you just read out, when you you're keeping section 5 as being 28 days for them to make the application.
Yeah.
So if you're keeping the 28 days for them to make the application, why are you limiting yourself to the expiration of 14 days?
No, it's not 20 days to make it, you know. Property seized under an order granted under subsection 2B. And 2B is a further order under subsection 1 may issue to appoint as a receiver authorizing to search for preservation. They say that that further order can only last for 28 days. And if you want that further order to go beyond 28 days, you have 7 days to apply for that extension of time, failing which you ought to return it in the first instance within 14 days if possible. But if the nature of the subject matter is not capable of delivery within 14 days, as soon as it's reasonably practicable, which would give the state a fair position to make best efforts.
Mr. Chairman, through you, the Attorney General.
Like I said, there's been lengthy discussion on this particular clause, and the Attorney General has put forward his comments in relation to this clause and the proposed amendments. At this point in time, I'm going to put the question, Attorney General, Senator Mark, members. We will follow like this. I'm going to put the question as proposed by Senator Mark on clause 38, subclause 5, which was agreed upon between the two. Then I will put the question on the new subclause 6 as proposed by Senator Mark, and then I'll put the question on the new subclause 6 as proposed by the Attorney General.
Just before you put the question, Mr. Chair, could you just allow us to amend the amendment that is proposed by Senator Mark by just correcting 38.8 it says there, it's supposed to be 38.5.
Yeah.
Yes, I will, in the putting of the question,
Okay,
I will
thanks.
allow for that. Honorable Senators, the question is that clause 38, subclause 5, be amended as circulated by Senator Mark. Those in favor say aye. Aye. Those against say no.
No.
Okay. Honorable members, let me just remind you. Clause 38.5, Attorney General,
Oh, sorry.
is the one that was agreed upon originally
Yeah.
by both sides.
Understood. It should be aye.
And I'm separating them because there's a difference of opinion in the whole clause.
Understood. I thought you were putting the whole thing.
No, I'm
Apologies.
putting the whole thing.
Yeah, I thought the
I've
third round.
separated out.
Understood.
So we'll try this again. Honorable Senators, the question is that clause 38, subclause 5, be amended as circulated by Senator Mark. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Honorable Senators, the question is that clause 38 be amended.
38 subclause.
No, yeah. Clause 38 be amended to insert a new subclause 6 as circulated by Senator Mark and further amended to delete the number 8 in brackets after section 38 and replace it with number 5. Is that correct? Yeah. Those in favor say aye. Aye. Those against say no. No. I think the noes have it.
Well, we have a further amendment on our plate. All right, let's go.
Mr. Khan.
No.
Mr. Khan.
No.
Miss Gopi Schoon.
No.
Mrs. Batiste Primus.
No.
Mr. Rambarat.
No.
Mr. Sinanan.
No. I take Michael.
Mr. Kazim Hussein.
No.
Miss West.
No.
Members, can we have a little silence so we can hear the vote?
Mr.
For clarity, could you just reiterate what we're voting on specifically, please?
Members, so again, I understand that this could be just a little bit confusing. Take a look at the circulated amendment in front of you by Senator Mark. That would be the second amendment, number 25 on that page 3. Thank you, Attorney General. Number 25 that says clause 38 and 6 in brackets. That is an amendment as circulated by Senator Mark, which was further amended to correct the typo that says 38.8 to actually say 38.5. That is what we're voting on now. What you have to understand as well is that in the deliberation, the Attorney General has put forward an amendment to also add a new subclause 6, which reads, Attorney General, where no application is made by the agency within 14 days of the expiration of an order under subsection 5, the property seized shall be returned to the person from whom it was seized within 14 days thereafter or as soon as is reasonably practicable.
That's it.
So that is the amendment as being proposed by the Attorney General.
Which will take after the vote on
Which will
Senator
take
Mark.
after the vote of the amendment proposed by Senator Mark. So the division as we are taking it right now is on Senator Mark's proposed amendment. Let the division continue.
Mr. Khan. Mr. Khan. Miss Gopi Schoon.
No.
Miss Batiste Primus.
No.
Mr. Rambarat.
No.
Mr. Sinanan.
No.
Mr. Kazim Hussein.
No.
Miss West.
No.
Mr. LeHunt.
No.
Dr. Henry.
No.
Mr. Singh.
No. Senator Mark, please.
Mr. Cummings.
No.
Mr. Dookie.
No.
Mr. Young.
No.
Mr. Boris.
No.
Mr. Thomas.
No.
Mr. Mark.
Yes.
Senator Beaker, please. Silence
Miss
while
Haynes.
votes being
Yes.
taken.
Miss Amin.
Yes.
Mr. Saddam Hussein.
Yes.
Mr. Obika.
Yes.
Mr. Ramdeen.
Yes.
Mr. Richards.
No.
Miss Choate, SC.
No.
Mr. Vieira.
No.
Dr. Dial Singh.
No.
Miss Dionaran.
Yes.
Miss C. Prasad.
No.
Mr. Timal.
No.
Mrs. Thompson-Ayi.
No.
Dr. Remy. Dr.
No.
Dylan Remy, sorry.
No.
Right, so the results of the division are 7 for, 23 against, and no abstentions. 7 for, 23 against, no abstentions, so it does not.
Honorable Senators, the results of the division are 7 for, 23 against, and 0 abstention. The proposed amendment is not approved. Honourable Senators, the question is that Clause 38 be amended as follows: to add a new subclause 6 that reads, where no application is made by the agency within 14 days of the expiration of an order under subsection 5, the property seized shall be returned to the person from whom it was seized within 14 days thereafter, or as soon as is reasonably practicable. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Honourable Senators, the question is that Clause 38 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 38 as amended now stands part of the bill.
Clause 39.
Honourable Senators, the question is that Clause 39 stand part of the bill. Honourable Senators, the question is that Clause 39 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 39 now stands part of the bill.
Clause 40.
Honourable Senators, the question is that Clause 40 stand part of the bill. Honourable Senators, the question is that Clause 40 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 40 now stands part of the bill.
Clause 41.
The question is that Clause 41 stand part of the bill. Senator Mark?
Yeah, Mr. Chairman, we have circulated again for the AG's consideration amendments to 41 subsection 2, and we are suggesting that we delete the word may and replace it with the word shall. In Clause 41.4, we delete the word may and replace it with the word shall. In 41.4, we also delete, Mr. Chairman, the words on an application made and replace with the words on an order being granted. There's a new subclause 41.6 that we are proposing, which reads, the agency responsible for registration of Trinidad and Tobago ships in Trinidad and Tobago shall, on an order being granted under subsection 5, enter the restriction in the relevant register. These are our amendments for the consideration.
Before the Attorney General response, I just have one minor change. That is at 41.1. I think it's a typo on the second to last line. Request the court to direct. I think that's two is left out. I don't know.
41.1, right? That what I read?
Mr. Chair, let's deal with the may and shall prescriptions. The legislative practice coming from the CPC's department is that administrative functionaries such as the Registrar General and other people are told may. The first time we actually adjusted that language was in the non-profit organization bill, where we went to the word shall. In any event, Bennion on statutory interpretation and parliamentary practice suggests that the court has well decided and articulated these positions, may and shall, and or, etc., which are traditional points. Insofar as it is a direction for the Registrar General coming at the court. So if you look at 41.1, where the agency makes an application for a property restriction order under 33, in respect of land, the agency shall be treated as a person interested in land. made under the application relates, the agency may, at that time, request the court direct the RG to restrict or prohibit dealings with the land. So insofar as the court is giving that, there's no objection to changing to the word shall, just for the sake of clarity in this position here. But for the record, there's no administrative fine that can find itself other than the penal clause on the court's direction. Now, so we can deal with that. Shall, may to shall in subclause 2. In subclause 3, it's where we treat with the agency making an application for a PRO under 33 in respect of a motor vehicle. The agency shall be treated as a person interested, to which the application relates, made on an application, and the agency may, at that time, request the court direct the commissioner. Yeah, I know, I'm reading 3 because it leads to 4, so I just want to put the position there. It's at 4, we say the Commissioner of Transport may. We can change that to shall because it's the direction of the court. In any event, for the record, the may and shall are read the same way in these parameters according to the CPC's practice. Subclause 5. So you say shall on application made under subsection 3. Right. And what I'd like to get, if I look at the words here, on an order be granted, if I could just indicate why we have gone for application as opposed to order. It's to keep it consistent with a lis pendens, which is not an order of the court under a restriction, but is effectively a caveat. So that's recognized under the Conveyancing and Law and Property Ordinance Act and also under the Real Property Act. And insofar as that is merely just the filing of a list, a thing, a court, we need to keep it consistent. This is going no further than the existing law recognizes. It isn't by way of order that the restriction happens. Yeah, but I'm giving you, it happens for vehicles, it happens, etc. Notice we've kept it for land at direction, so we're going with the concept of a lis pendens, and we're keeping it similar in terms of threshold for ships and for vehicles. So we didn't want to go by way of an order, it's a list. If I take it from the ship's aspect and I go for actions in rem, and I look at the manner in which you may arrest a ship, there's also upon the filing that the list actually happens at the registry for drogas and other aspects as well. So we wanted to keep it as set out in subclause 4. We agree with the changing of may to shall.
In subclause 2?
4. 2 and 4. Change may to shall. So that takes care of line 26, line 27. If we go to line 28, we have respectfully declined line 28 for the reasons volunteered. If we get to line 29 of the proposed amendments, the agency responsible for registration of Trinidad and Tobago ships in Trinidad and Tobago shall on an order being granted under 5, enter the restriction. So in 5, we said where the agency makes an application for a PRO under 33 in respect of a ship, the agency shall be treated as a person interested in the ship to which the application relates or to which the PRO order is made on the application relates, and the agency may at that time request the court direct the agency responsible for registration of Trinidad and Tobago ships in Trinidad and Tobago to restrict or prohibit dealings with the Trinidad and Tobago ship. What I don't get is the distinction recommended by adding in a new subclause 6 in light of the prescriptive language of 5. Could I be assisted in that regard?
Senator Mark?
I think that
the Attorney General is asking for the reason for new subclause 6 in relation to, given that subclause 5 treats with what you're trying to treat with.
Is it to capture the positive step of entering in the register? Or was it because you are asking for the order to be made as opposed to direction? Which is it?
It's the harmonized.
It's the harmonized, yeah, it's the harmonized.
section, which one?
If it is to harmonize with the approach to have the entry into the register, then there's no objection to the clause.
I just have a query with respect to this. Is there a registry for these ships? I'm not aware.
Yeah, so there's the Maritime Registry, the Drogas Registry. There are a number of registries
That's under
in
the
existence.
Maritime Division, under the Ministry of Goods
Yes.
and Transport. The second thing is that there's no definition of what a ship is, because let's look at the reality.
Interpretation Act.
Yeah, Interpretation Act has a definition.
Well, plain and ordinary meaning.
You see, the thing is, because we have, if we look at our circumstances right now, a lot of pirogues will be bringing in drugs into the country. Will those smaller vessels be regarded as a ship or a vessel or a boat?
So what we're treating with here is ships which are on registers, right? As opposed to vessels which are unregistered.
So then my next question would be, what will constitute a ship to be registered?
That which requires registration. So the maritime laws tell you what you need to register. So when you bring a foreign vessel to Trinidad and Tobago of a particular size and class, you have to register in the various sub-registries, drogas, ships, etc. Vessels like pirogues, etc., which are currently under our laws unregistered vessels, those are subject to seizure as a matter of fact, by literally impounding them. So we didn't intend...
Once they're within territorial sea.
Correct. You see, here is where we're just putting the lispendants on notice to the world of somebody else's interest. So you have a certificate of registration for a car, you have registration effectively for land, there's titling. Wherever we have titling, we're treating with it. If it is an untitled thing, then you treat with it by physical possession. Okay, so we can agree to the subclause as proposed, Mr. Chair, in line 29 of the amendments. So effectively, may to shall.
So 1 second, Attorney General.
The only one is the subclause 4, second amendment at line 28. If withdrawn, we could then agree to the other three.
Senator Mark? All right. So Attorney General. Right. So Attorney General, just for clarification, clause 41, subclause 1, line 1, 2, 3, 4, 5, 6, line 6, after the word agency, you indicated that that word may would change to shall or no?
No, that stays as is, sir.
That stays as is, okay.
Yep.
And in relation to Senator Hussein's proposed amendment to insert the word to after court in the next line, did you speak to that?
To direct, to restrict. Yes, to is fine.
Okay.
And may I, Mr. Chair, I just wanted to bring something to the Attorney General's attention.
Is it?
We limit, no. We're on 41, right?
Yes, we are 41. Yes, okay.
If I may, 2 is also missing from subclause 3, eh? 3
Where
lines
exactly?
from the bottom.
What line down at the bottom?
3 from the bottom, after court.
So time request the court to direct. Attorney General?
Sure.
Okay. Honorable Senators, I will put the question on clause 41 as amended with a proposed amendment by Senator Mark, having withdrawn subclause 4, and then further amended by the Attorney General. Yeah, okay. Honorable Senators, the question is that clause 41 be amended as circulated by Senator Mark with clause 41, subclause 4 withdrawn. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Honorable Senators, the question is that clause 41 be amended as follows. Clause 41, subclause 1, after the word court, insert the word to. Subclause 3, after the word court, insert the word to. subclause 5, after the word court, insert the word to. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Honorable Senators, the question is that clause 41 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 41 as amended now stands part of the bill.
Clause 42.
Honorable Senators, the question is that clause 42 stand part of the bill. The question is that clause 42 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 42 now stands part of the bill.
Clause 43.
The question is that clause 43 stand part of the bill. Senator Mark?
Yeah, we are proposing, Mr. Chairman, that in clause 43, and we want to amend this, we want to delete 3 months and replace it with the word an order with 1 year, with 1 month.
1 year.
1 year rather.
Attorney General.
No, before you go to the Attorney General, Mr. Chair, I'd also like the Attorney General to consider subsection 5 in line 3, where the court is satisfied. Replace the word "it may require" the agency to "it shall require" the agency. I'd like the Attorney General to remove the word "may" and replace it with the word "shall," because the court has already been satisfied. So they shall execute the court order.
Attorney General.
Mr. Chair, I want to remind that in civil proceedings, the appellate route for a substantive appeal happens within a certain time frame, 42 days. The question is whether 3 months is appropriate in these circumstances. So 43 is the compensation provision. 43.3, if a high court has made a decision by which no property restriction can be made in respect of the property, the application for compensation shall be made within 3 months, from beginning with the date of the decision. We think that that would be in keeping with the civil procedure rules that we have at present. We're minded to hear the perspectives on this particular point, but that's the rationale for why we anchored it in the way we did.
Senator Vera.
Yes, AG. So compensation is something I'm sure most citizens would be very interested in knowing about. And I'm making my comments from the point of view that sometimes the citizens need to be able to read these acts in a way that they can easily understand them without them having to be filtered through the lens of professionals and lawyers and such. Now, my first question is, the way I read this, so the property is restricted, the court finds it's not recoverable property, the innocent owner or holder can apply for compensation. That's great. Does it mean that he applies for compensation before the same judge in the same proceedings, or does it mean this entitles him to go and bring an application separate and apart after the matter? That's one question. Second one, you must make your application for compensation within 3 months, either from the date of the decision or the proceedings having been discontinued. So my next question is, what happens if he makes his application 4 months? Is he time barred? Does that mean he has no recourse?
Attorney General.
Sure. The matter that will be intituled before the court is the matter of the court versus the property. And the application for compensation would flow in the same proceedings. The question is whether that is to be managed by way of rules of court or in express legislation. As we have drafted it here, it is intended to be in the same proceedings, because this is within the due process of the event. if a High Court has made a decision by which no property order, so the High Court is already in locus.
That would be ideal.
Right, but it's there. So it's in subclause 3. If a High Court has made a decision by which no property restriction order can be made in respect of the application for the property, the application for compensation shall be made. Notice it says the application. It's in those High Court proceedings. So we see the language as expressed here as being quite clear in saying, look, it's in those proceedings. Whilst it's true that persons need to understand the law, if that was true, it'll make a mockery of the entire civil proceedings that we currently engage in, including the civil proceedings rules and practice directions, which are unintelligible for the average human being. Take Trincan alone, the mayhem that was unleashed on Trinidad and Tobago by the Court of Appeals decision, which was against the overriding objective and against the express provisions of the CPR themselves. The Privy Council determined in that case that the Honourable Justices of Appeal were on a frolic of their own and then reversed them. So that's just to ground the point that law is to be interpreted in a very strict arena. When we get to that, we've harmonized it with the civil proceedings to say, effectively, around the 42-day marker, right, which is where civil proceedings aspects come. It is open to us to say, or within such further period of time as the court may allow, to allow someone to approach the court in the interest of justice argument.
Because you were very happy to give the state extensions and as practicable, I think the same should apply for the citizen, the innocent holder.
So what's the proposal?
I think what you have said is a good starting point for consideration.
Yeah. Senator Mark, clause 43.8, proposed amendment. Could you elaborate on that so that the Attorney General could respond?
Thanks, reasonable. Let me see 43.8. 43, let me guess. Just a second, sir. The amount of compensation to be paid under this section is the amount of the High Court thinks reasonable, having regard to the loss of any
Chair, while Senator Wade is pondering, Senator Mark is pondering, B and C, there seems to be a fundamental error there. Doesn't make sense to me.
Which subclause, Senator E? 43? 43.3, B and C?
Yes, so
Attorney General?
It falls apart after you pass A. Something is missing. Chair. If I know what the intention is, I can help you.
Senator E, 1 second. Let the Attorney General.
I'm working with the CPC's position to capture the expression for subclause 3. So it's just putting it into formula, which is just a little bit of wordsmithing on this end. The intention we're working out here now, just to assure you, is that we apply a 3-month limit or such further period as the court may consider just in the circumstances. So we can go for that ability to tell the court, look, you said 3, but I didn't know, I came back, my circumstances now permit, please allow me the enlarged time.
Yeah, because you could have been he could have been sick, having been so traumatized by the
Understood.
event.
So now to Senator Ahi's point, which is how we factor subclauses B and C. Subclause B treats with the event where the High Court made an order, but somebody was appealing. So it's to treat with that circumstance if an application is made for leave to appeal with the date on which the application is withdrawn or refused. So that takes care of making your compensation application after the end of the Court of Appeals matter. Or if the application is granted on which the proceedings on appeal are concluded. So it takes you to the end of the appeal. And notice that we're talking about appeal in the larger sense because there's a right of appeal to the Privy Council or conditional leave to the Privy Council pursuant to the Constitution. So I'm just working on the formula of words to capture the time frame for those three particular circumstances. A, the High Court. B, leave and you withdraw or it's refused. And C, the completion of the appellate process. And we're proposing that that be 3 months or such further period as the court may consider just in the circumstances.
That is
Okay?
the last part is right.
So I just need a small bit of space to do that.
Before you do that, sir, why would you need leave to appeal? No, but you know, with my parallel, with a different way. You don't need leave to appeal. So it should that should be out. This doesn't fall within one of the categories under Section 38 of the Supreme Court Adjudicative Act. These are civil proceedings. 38(2).
Yeah, so the issue of leave to appeal came to me first as one of those circumstances. I'm just checking it now. Okay?
It's not. It's interlocutory and cause.
It's the point of the interlocutory aspect, you know. So that's the only bugbear. And what happens if it also involves costs?
But no, this can't be.
I understand,
cost,
but
first it has to be cost only. So this can't be cost only. And then secondly, these are not final. It's not interlocutory, but they are final proceedings. These can't be final proceedings under the recognized Abu Bakr test under White and Brunton.
The thing that I'm looking at is 3 being grounded if a High Court has made a decision by which no property restriction order can be made. If there are any ancillary proceedings within the interlocutory or cost aspects that are tagged onto that, can I reasonably contemplate that a judge would always clean separate them? Or would there ever be a conflation of circumstances where they may argue, and the judiciary is not always right, we see that every day, that there is a conflation for which leave is required?
No, but that has to match back to Section 38(2) of the Supreme Court Adjudicative Act. If it's separate, if it's bifurcated and you have a cost order only, then 38(2) will already provide that you need leave, but that wouldn't apply here. And these are not final proceedings under 38(2).
So, Mr. Chair, if I could recommend, so that we don't detain the House, if we could have a look at this, and we will just do a little bit of surgery, because this language requires just a little bit of more contemplation.
Okay, honorable senators, we will stand down clause 43.
I want to check Section 38 of the Supreme Court Adjudicative Act.
Attorney General,
Mr.
just
Chair.
for the interest of time,
because they don't get it.
I am considering putting Senator Mark's amendments first and then standing down because you have subsequent amendments to that. We did not treat with clause 43, subclause 8 as proposed by Senator Mark. Senator Mark, are you ready to give a brief explanation on that subclause so the Attorney General can treat with it immediately before we move forward?
All right, well, I'll ask Senator Ramdin to give this one.
Okay, Senator Ramdin.
Mr. Chair, the amount of compensation to be paid under this section, as it stands, the provision reads, the amount of compensation to be paid under this section is the amount that the High Court thinks reasonable, having regard to the loss suffered and any other relevant circumstances. The section, as it is presently framed, leaves it in a very wide open discretionary way for the High Court to grant damages. And one must understand that in these circumstances where you have deprived someone of their property, and that deprivation of property is found not to be in accordance with the terms of the Act being recoverable property, the High Court shouldn't have any discretion as to what is the loss that has been suffered. If the loss is proved as to be a direct consequence of the deprivation of liberty, then the citizen must be entitled to recover whatever loss is directly suffered as a result of the order that has been made in the circumstances. Secondly, I don't think it's proper for us to put the amount that the High Court thinks is reasonable. It just does. It can't work like that where you have the deprivation of. To be proportionate, the law must prescribe that whatever loss flows directly as a consequence of the deprivation of the property right, that the citizen be compensated for that, and it must not be anything narrower than the loss that has been suffered by the citizen, and that is the principal basis upon which the amendment is proposed.
Attorney General.
Mr. Chair, we looked at the wider language to imply a wider category. So I do understand the pointer back to the direct losses nexus range. But what we had suggested here in subclause 8 is the amount the High Court considers or thinks reasonable, we've used the word thinks, having regard to the loss suffered and any other relevant circumstances. And we were really trying to encapsulate a broader form of consideration rather than narrower. There's an argument that can prosper to say, well, look, direct losses don't include indirect losses. And then that disaggregation could put somebody out of, I'm going to use this quite inappropriately, but to capture the concept of aggravation, of vindicatory, and I'm borrowing the compensation, and I said inappropriately, to treat with damages as opposed to compensation, which is really, meant to be tied to physical and actual losses. So what we intended here, insofar as we're in virgin territory on this particular aspect, or I shouldn't say virgin, the common law would take care of this and the rules would take care of this. But we intended to be wider rather than narrower. And we thought that having regard to the loss suffered and any other relevant circumstances would then all be enveloped under reasonableness. So we thought that we would go on the wider approach as opposed to the narrower approach.
So I will now put the question on clause 43 on the proposed amendments by Senator Mark. Honourable Senators, the question is that clause 43 be amended as circulated by Senator Mark. Those in favour say aye. Aye. Those against say no. No. I think the noes have it. Honourable Senators, I will now stand on clause 43 to allow the Attorney General to do some more preparatory work on his proposed amendments for clause 43. As such, we'll move on to clause 44.
Clause 44.
Honourable Senators, the question is that clause 44 stand part of the bill.
Mr. Chair.
Senator Mark.
Mr. Chairman, in this clause, we are moving from property restriction order to a civil asset forfeiture order. And the language here tells us that the applicant, which is the agency, can, or their representative, can proceed to make this application to the courts or to the High Court, and the language is not explicit. But what comes out clearly at us is that this can be done ex parte. So you're moving from one level to another level. From freezing, you're going to restriction, and now you're going out to forfeiture. So what I am proposing for the AG's consideration, once you are tampering with this level, I would like that it be made explicit that it must be inter partes.
Attorney General.
Mr. Chair, if I could just for some sense of order, not deprecating anything that Senator Mark said, we're at the end of the opposition's recommendations for amendments to the law, which is wonderful. We're at the smooth passage now. The only recommendation for clause 44 is that of the government, which we have not put. So I've circulated an amendment.
Sorry.
So for housekeeping purposes, could I just
Yes, you
offer
can.
that?
Yes,
so,
you can. I would
so
prefer you do.
We propose in section 44.4 that the application be supported by affidavit, not from an investigating police officer, but the 3 categories of investigating officers who are charged with that responsibility under the control of Customs, the Chairman of the Board of Inland Revenue, and the Commissioner of Police within the defined ranks. In those circumstances, we propose that we delete the word police as it appears in the 3rd line in subclause 4 of clause 44. And that's the rationale for the recommendation.
So the Attorney General has put forward his amendment as circulated. Does anyone have comments in relation to that particular amendment?
Yeah.
So I will treat with the question in relation to the Attorney General's amendment. The question is that clause 44 be amended as circulated by the Attorney General. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Attorney General, you want to respond quickly to Senator Mark's comments?
Could I, please correct me if I'm wrong, I understood that Senator Mark's position in section 4, in clause 44, as it relates to the move now to the permanent side of it, which is the civil asset forfeiture order, that there was a question as to whether this thing can be done ex parte, and an insistence that it ought to be inter partes. Well, respectfully, there are going to be circumstances where there's a blend between the two. This law, as crafted, requires that all steps are taken to ensure inter partes and more. We also include third-party attendances, interested party attendances, and when we tie it into the definition of clause 7.9 as to what is recoverable property, and clause 50, which treats with what is legitimately owned, we ensure via publication in the Gazette and in the newspapers that all persons are made aware so that they can at least have some degree of actual notice as opposed to just constructive notice of proceedings. In those circumstances, we're confident that we're broader than inter partes. Where the blend comes with the ex parte approach is in circumstances where that person cannot attend, notwithstanding those aspects. And those, of course, happen, for instance, with absconding debtors, etc. So we respectfully cannot agree to an insistence of pure inter partes because there will be circumstances of fact that would frustrate that aspect.
Mr. Chairman.
Senator Vera.
Okay. Thank you, Chair. And I think the 3 gears, as I had suggested, seize, explain, forfeit. The critical point here is that nothing is going to be taken away from anyone until a court has made a determination. So the ex parte application at highest just means that it's been frozen.
Yes.
But it's going to be there, it's going to be examined and interrogated, and that's a safeguard.
Thank you.
Mr. Chairman, if I may, whilst that is still to be determined by the courts, the mere fact that the Attorney General has said, once this procedure kicks in, ex parte, it can find its way in the Gazette. It can find its way in the newspapers, publications. You remember, this matter has not been determined, but it's been publicized. Reputational damage is real in those circumstances.
Yeah. Senator Mark, as much as you're engaging and explaining
so I'm asking,
your point of view, one second.
Yeah.
I understand what you're asking. Remember that there must be a proposed amendment. You've put forward a point, the Attorney General has responded, Senator Vera has added. Are you adding any proposed amendments specifically at this point in time?
No.
Good. Senator Mark, so the Attorney General has responded. I am going to continue to put the question in relation to...
I have a specific amendment, sir.
Do you have a specific amendment?
Yes, I'm proposing,
ask that question.
I'm proposing that in clause 44, we place, and I'm leaving that up to the Attorney General, we want to proceed with an inter partes.
And the attorney, I understand that. So you
So
spoke to that
that is
before.
my
Good.
amendment.
So you are formally putting forward an amendment?
Yes, I'm formally
that you would
putting-
like a question
yes.
put to. Honourable Senators, the question is that clause 44 be amended as put forward by Senator Mark. Those in favour say aye.
Aye.
Those against say no.
No.
I think that noes have it. Honourable Senators, the question is that clause 44, as amended by the Attorney General, now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 44, as amended, now stands part of the bill. Honourable Senators, we, for the most part, have come to the end of the circulated amendments put forward by Senator Aye, Senator Mark, and the Attorney General. What remains is new clauses as proposed by Senator Hussain, which will be treated at the end of dealing with the original clauses. At this point in time, moving forward, we will take the clauses by way of parts as organized and outlined in the bill.
Please, we have been going very nicely, and you have exercised patience. We do not want to rush. So even though we have not put formal amendments, it does not mean to say that in each clause we may not want to share with the Attorney General some areas where we would like him to consider for purposes of amendments. But I think that if we rush to just everything in parts, I don't think it's, I want to give you the assurance that we are not going to delay any process. There are some clauses that we are just going to go through, but there are others, Mr. Chairman, that we will want to engage the Attorney General.
And Senator Mark, let me assure you that and it's not my intention to rush anything. What I am treating with and have treated with for the day thus far primarily is the amendments as circulated by all those who wish to circulate amendments. What we have is come to the end of that process. I am going to take it in parts, as I have indicated, assuming that everyone has had sight of the bill and, having gone through that bill, was able to propose amendments and did do so in the time allotted to do so. If you have an amendment to any clause that comes up in any of the parts, you can voice such concern, but we will be taking it in parts from this point forward. Clerk?
No, Mr. Chairman,
Senator Mark, I am taking it in parts from this point forward. Moving forward, Senator Mark. Clerk.
But we are not in a dictatorship here, you know.
I know you're not
This
in a
is a
dictatorship,
democracy.
Senator Mark. I'm not engaging in a back and forth with you. I have indicated as the chairman of these proceedings how we are going to proceed. You will be allowed to raise concerns on any particular standing order as put forward. Senator Mark, that is my ruling. Clerk.
Is there a public meeting tonight, sir?
Clauses 45 to 57.
Honourable Senators, the question is that clauses 45 to 57 stand part of the bill. Senator Hussain.
Clause 45, Chair, through to the Attorney General. AG, we had defined specified offences in the definition section. When you look at 45, 2A and B, I see the word or the term a particular offence appearing. I don't know if that should be changed to a specified offence, seeing now that we tie down the bill to the second schedule of the Proceeds of Crime Act. Because with the criminal property is defined based on a specified offence and the instrumentality also.
So 45(1) treats with the general power to grant a civil asset forfeiture order.
Right.
High Court may, where it is satisfied on the balance of probabilities that the recoverable property should be forfeited, grant a civil asset forfeiture order to forfeit such property.
Okay.
Subclause 2 is where we treat with the specific types of property. A, criminal property, B, instrumentalities, and C, terrorist property. Insofar as these types are treated separately, it's to drill down into the nature of the property.
No,
I know your point. I'm coming to the point of specified offense. I got you when you said it, right? So the criminal property is not necessary to show that the property is derived directly or indirectly or whole in part from a particular offense. Your question is whether that is to be, whether there's a danger or risk in saying particular offense insofar as we have specified that it must be a specified offense. And my answer to that as we go through A, B, and C is that we are talking specifically about only specified offenses under poker, but if you go to the second schedule of the Proceeds of Crime Act where we treat with money laundering or we treat with breaches of the Anti-Terrorism Act, there are offenses under the Anti-Terrorism Act which then all become specified offenses. So this is intended to treat with that. They all are enveloped in the meaning of the manner in which the investigation can happen and for the things that are specified offenses. So we don't think that there's an incongruity between the two.
By using the word particular offense?
Correct, because they are enveloped in the concept of a specified offense.
So it forms part of the subset, that's what you're saying?
Yes.
But what's the danger in just removing the word particular and using specified?
Because if you go to the second schedule of poker,
yes,
and we see the reference to breaches of the Anti-Terrorism Act.
The ATA is covered in C, specifically because when you look at C Roman 1, it deals with property derived from specific terrorist act, which is defined. So I'm comfortable with that. My issues with respect to A and B, using particular offense.
And it comes within the definition of criminal property and instrumentalities of crime, insofar as they come effectively from predicate offenses, which must always be within the parameters of this law, specified offenses.
Attorney General, completed?
Yes, sir.
Honorable Senators, the question is that clause 45 to 57 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 45 to 57 now stands part of the bill.
Clauses 58 to 67.
Honorable Senators, the question is that clause 58 to 67 stand part of the bill.
Mr. Chairman.
Senator Mark.
There is in the Hansard, where the Attorney General gave an undertaking that he will deal with a number of clauses here that he could not have dealt with downstairs. I would hope that he would honor his commitment.
Mr. Chair, I'm perfectly prepared and capable to do that. What the Leader of the Opposition indicated is that the Senate would circulate amendments. So we've been in our second day of committee stage right now.
Nowhere here did the Honorable Leader of the Opposition say that. No, I'm just saying, you see, it's either we operate
Senator Mark
on principle or we are not.
Senator Mark.
You were going good all the time, but
Senator
I don't
Mark.
instructions, but you just gone.
I have indicated how we would proceed, and that is how we're going to proceed. So unless anyone has comments in relation to clauses 58 to 67,
We have many comments, sir.
Okay, well, let's deal with them.
In 58, sir, we are saying that we would like to propose a specific amendment that under 58, that we deal with, first of all, matters that are being heard in the courts should not be again be considered ex parte. We believe that this can damage people's reputation, and we agree wholeheartedly with the Law Association on this matter that we should move from ex parte to inter parte.
This is clause 58.
This clause 58, so I'm proposing for the Attorney General's attention that we should move from ex parte to inter parte.
Attorney General.
Mr. Chair, the position is that there's a need for both ex parte and inter partes, and we do that. On the preliminary unexplained wealth order aspects, we provide for, of course, the ex parte route, which is, quite frankly, normal. The existing common law, as it is embodied in the Ant and Pillar regime in particular and in other areas, involves ex parte grants by the court. Where the caution and proportionality is to be found is that there can never be an unexplained wealth order in final form until the inter-parties process has been properly carried out in the circumstances set out in the bill. There is a publication requirement, there's a notice requirement, third parties have certain interests there, the court acts in the interest of justice. It's in all of those circumstances, therefore, that we unfortunately cannot agree to making this all inter-parties, because it would make it extremely difficult to operate the law that way, because it just can't be done that way in certain circumstances.
Mr. Chairman, may I continue?
Senator Mark, yes?
Yeah. I'm saying in 58 subsection 2, A, B, and C, and also B and C, we would like to propose amendments to B beyond any reasonable doubt. And this thing about reasonable suspicion, which is the principle that is guiding this section 2, we would like the Attorney General to have this thing reconsidered, because, as you know, we have a certificate that we are coming with as part of the preamble, where we are saying that this bill requires a 3/5 majority. So consistent with that particular submission, we are proposing in this section that the Attorney General begin to carve and craft this section to reflect beyond reasonable doubt.
Attorney General.
Well, Mr. Chair, that just makes absolutely no sense with the greatest of respect. This is clause 58. It's the application for order for declaration. 58.2 says the application shall be accompanied by an affidavit stating identity of respondent, the grounds by which the applicant reasonably suspects. If you take what Senator Mark just said, Senator Mark is asking the Parliament to accept a recommendation that the applicant must have proof beyond reasonable doubt of something. I mean, that happens in a court process as a standard of proof. So it just has no home or place in the application.
May I invite the Attorney General to journey with me to 61?
Sure.
And see if what I've said can be grounded and rooted here from all reasonable grounds.
Sure.
To the beyond reasonable doubt.
Sure.
Attorney General.
Grant of a preliminary unexplained wealth order. This is preliminaries provided for clause 61. Clause 61 says that the court shall be satisfied that there are reasonable grounds to suspect. And it's at that point that the court then invites someone to come to court to basically be the subject of interrogatories, to file a declaration in a prescribed form, and then to be subject to interrogatories. This is no different from Section 32 of the Proceeds of Crime Act, where you can be summoned for the same purposes on reasonable suspicion. For the record, Mr. Chairman, if you turn to Section 32 of the Proceeds of Crime Act, and you go to the specific language in subsection 6 as it appears there, the conditions referred to in subsection 2 and 3 are, in the case of subsection 2, that there are reasonable grounds for suspecting. B, reasonable grounds for suspecting. C, reasonable grounds for suspecting. D, reasonable grounds for believing in the public interest, certain other matters. And this is where a police officer may, for the purposes of an investigation into a specified offense, apply to a judge for certain parameters. So we are grounded squarely within the parameters of the existing law, which is the Proceeds of Crime Act. We take comfort in the fact that there must be a satisfaction by the judge, but this is only at the preliminary stage. It does not lead to anything more than an obligation to fill out the form and then to be subjected to interrogatories.
Mr. Chairman, I'd like to also propose that in 60, we be consistent with what has gone on before.
60?
Yeah, that is clause 60 of the very unexplained section.
So we've gone back?
Yeah, I mean, going back, we're doing the whole section, that's all. I was told by the chairman,
Senator Mark.
So in
is the
clause
whole
16,
thing
Attorney
delivered?
General, all right, Senator
It's
Mark.
like
Senator
SPA,
Mark.
all.
Senator Mark.
So clause 60 what?
No, I'm dealing with clause 60, Mr. Chairman. And I'm just asking the Honorable Attorney General that we ought to be consistent. Because early on we said knowingly, or is it not all you had used, Mr. Chairman?
Sure.
So I'm just saying that we have to be consistent.
Previously, we dealt with recklessly or willfully, as opposed to knowingly and willfully. There's a proper conjunctive association in this mens rea, knowingly and willfully, so there's no need to put the or.
Oh, there's no need, okay. Let us go on to the other page, Mr. Chair. Yeah, Mr. Chairman, again, on the 65, we just want to be consistent. Again, on the A, we have the balance of probability, which is a very low threshold. Again, we'd like the Attorney General to consider that this should be beyond reasonable doubt.
Senator Mark, let me just interject here at this point, because it seems that you have a proposed amendment or a line of proposed amendment that could be applied within the part to certain clauses. So you're asking in relation to the balance of probabilities and changing the threshold. Where that is the case, would it be easier for you to just identify within the part that I've identified as we're treating with, where that particular line of proposed amendment applies to certain clauses? So in other words, you don't have to search out each clause and then repeat the same amendment, but indicate that this is the amendment that you want to propose, where it applies within the part or to certain clauses.
Would you just pull this up?
Well, it makes it much easier than going through one by one, proposing the same amendment.
Well, I would appreciate, I think I'm appreciating what you're saying, but I don't think this part has many, let's say, clauses. I think we should be through it. It's just only about, what, about 7 or 9 clauses?
Okay, so Senator...
So can we go one by one, sir?
No, we're not going one by one. I put the question in relation to the part. All I'm asking is that as much as you have one singular line of proposed amendment, which is a common thread throughout, that you indicate it's a common thread throughout so that we can treat with it as such. Attorney General, clause 65, same proposed amendment as has gone before.
Mr. Chair, this is a balance of probabilities aspect. This is, again, pegged upon the order in rem. We, from a policy point of view, cannot go to proof beyond reasonable doubt. We are maintaining the civil standard and burden.
Mr. Chairman, may I also invite a new subclause 65(3)A for the Attorney General's consideration. And it reads, where the court makes an order under subsection 3, the court shall specify the time within which the amount ordered shall be paid into the seized assets fund. So that's a subclause, a new subclause I'm proposing for your consideration.
Attorney General?
Through the Attorney General, that is.
Well, Mr. Chair, the obligation in 65(3) is stated in the positive. Where the High Court makes an order under this section, the order shall specify that the respondent is liable to pay. And then we categorize what that unexplained wealth amount is, equal to the amount satisfied, etc. The time to pay is usually a matter of the attorneys representing the respondent in that application, the defendant in that application, to say, well, we wish to have an enlarged time, we wish to have conditions, etc. So that is really a matter for the court to consider. We don't want to necessarily prescribe that. There may be circumstances where the court may say you shall pay it forthwith, because there may be other circumstances before the court. So we prefer to reside within the traditional mechanisms that prevail in the court, where the court will, upon the invitation of attorneys for the respondent, indicate whether it is prepared to enlarge time or not.
Well, that's a specific subclause, sir.
You could have a practical problem like just getting foreign exchange.
Correct.
Senator Hussain.
Thank you very much, Chair. Just for the record, I'd just like to register my dissent with respect to clause 65, subsection 4. I don't believe that the burden should be on the respondent, but that it should be on the applicant. So that is just for the record, please, Chair.
Mr. Chair, for the record, I reside in the comfort of section 5(2)(f) of the Constitution, which says that there is nothing odorous or onerous in respect of someone having to prove a fact in a reversal of burden. And that is to be found in a plethora of cases. And in this circumstance here, who better to explain someone's position than the person themselves? So we hear this constant mantra right now of people being called upon to explain themselves. That's exactly what we're asking, because you have the facts yourself. You are faster out of that dance by your own hand and mouth.
Honourable Senators, the question is that clause 58 to 67 now stand part of the bill. Oh, you have more amendments?
No, I made, you see, because we're doing it in GRAP, you're not paying attention. When I say you're not paying attention, so I'm not everybody under pressure. But I did, in fact, put an amendment. I am not under pressure. Speak for yourself. So I think that it is important that we do things properly. So, otherwise, we are going to be in trouble, you know.
So, Senator Mark, I am at pains to understand that I have a sheet in front of me with amendments put forward by your good self, on behalf of the opposition bench, 31 in number, all the way up to clause 43, subclause 8. As,
for example,
as amendments, I assume in its entirety, given the time frame that was given. If we are treating the clauses as we're moving forward, based on the premise that we have dealt with the amendments put forward by all, and we are taking them in batches at this point, I am not inclined at this time, unless you have it written, to put forward the amendment as per question. You have put forward a suggestion by way of a proposed amendment to the Attorney General, who has responded either in the negative or the affirmative. And then I move forward by putting the proposed question on the clause in the original bill.
Can I be invited, sir?
Sure.
Mr. Chairman, in clause 67, sub 2, the Attorney General did give an undertaking in the other place that we would look at this very carefully, because the Honourable Attorney, I think the Leader of the Opposition, had proposed the deletion of 67.2. But because of time constraint downstairs, we were told that it would be dealt with upstairs. So I don't know if the Attorney General would like to give his final views on this particular proposal.
General, there's no need to respond to that. What I'm saying, Senator Mark, is that we have followed a procedure where all members, not just members opposite, were able to put forward amendments for 2 days. Amendments were put forward, as I've indicated. I'm not going to repeat it again. I have all of the amendments here. We've been going through them, and we've been treating with them as the day has proceeded. I have indicated that we are moving in batches after we've treated with all of the amendments, save for the new clauses as put forward by Senator Hussain, as we proceed forward in this exercise. Everyone, as we are moving forward in those batches, I'm assuming, has read the bill. And if you have other amendments within that batch, you are being allowed to voice said amendments on the floor, to which the Attorney General is responding to those amendments. Where he is not accepting those amendments, I am putting the question on the clause in the original bill. That is what we're doing. So at this point in time, the last amendment that was voiced was to 65. We have
Okay.
up to 67 in this batch.
Yes.
Do you have anything to voice by way of the original clauses and proposed amendments between 65 and 67?
Of course.
Proceed.
Mr. Chairman, may I just indicate to your good self and to colleagues here, the government took 4 years almost to prepare this bill. We got this bill to deal with in 96 hours. So you can't expect us
Senator
to have gone
Mark,
through this bill
don't,
in the
I
detailed
really,
way that we would have liked to.
Senator Mark, I'm not
All right, Mr. Chair.
inclined to haggle, nor do I want to get into a tete-a-tete or a tit-for-tat.
Yeah, but you're assuming...
And no, Senator Mark, can we proceed?
Yeah,
Do you have comments in
Mr.
relation
Chairman,
to 65
may I
to
suggest
67?
for your consideration and as an amendment that we delete 67(2) as a specific amendment?
67(2)?
Yeah, clause 67, subclause 2. We are proposing that that be deleted completely.
Attorney General, 67 subclause 2, the proposed amendment is that it be deleted entirely.
Enforcement of unexplained wealth orders, subsection 2 provides that the order against the respondent may be enforced as if it were an order made in civil proceedings instituted by the applicant under section 58(1) against the respondent to recover a debt due by him to the state. It is just a method of application. It's standard law. Unfortunately, we don't agree that it should be deleted.
Senator Mark?
Can you put it, sir? I am not responding. Just put it and let's go forward. Yes, he's not agreeing. I am sticking to my guns. So put it to the vote, and we will vote for, and they will vote against. Yeah.
Can I look at something before that? In 65, the second line, the change had to has. 65(1), line 2. I think you're dealing with an existing order, so change had to has.
So where the High Court has made a preliminary unexplained wealth order,
The next
which
one.
had not been revoked.
Which has not been. It's still existing, so you want to do certain things.
CPC?
Has.
So, Senator Mark, you have proposed the amendment to the Attorney General, who has made his response in the negative. I am going to put the question on the batch and follow the procedure as I had it. So the question is, Honorable Senators, the question is that clause 58 to 67 now stand part of the bill.
Mr.
Those
Chair,
in favor say...
Senator Thompson I raised an amendment to clause 65(1) at the second line. She asked whether the word had in the second line should be has, and I believe she is correct, Mr. Vice President, Mr. Chairman.
Had should
that
be
the word
has?
had should be has. So delete the word had and replace with the word has.
Honorable Senators, what I'm going to do, because there is an accepted amendment to clause 65, I will put the question for clauses 58 to 64, propose the amendment by way of procedure for clause 65, and then move forward from there. Attorney General, understood?
Yep.
So
Clauses 58 to 64.
the question is that clauses 58 to 64 stand part of the bill. Honorable Senators, the question is that clauses 58 to 64 now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Clauses 58 to 64 now stands part of the bill.
Clause 65.
Honorable Senators, the question is that clause 65 be amended as follows. At subclause 1, delete the word had and insert the word has. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Honorable Senators, the question is that clause 65 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 65 as amended now stands part of the bill.
You see, because we are moving at such a pace, I just wanted to bring to your attention clause 65 2B, whether the property was obtained by respondent before or after the coming into force of this act. Remember, I brought to your attention, sir, that we are not supporting retroactivity or retrospection in that regard. So we will not support this particular proposal. But if you go in grab, you might want it. So this is a separate one. So
you're proposing to delete 65
yes.
subclause 2 subparagraph B?
Yes, sir.
And Attorney General.
Mr. Chair, we have already accepted clause 4, which treats with the general retrospectivity. So it would make a mockery of clause 4 if we were to treat with clause 2. So you can say, you can look at the menu, but you just can't eat effectively. So we reject the submission put for those reasons.
Okay, so I'm now going to put the question again. The question is that clause 65 be amended as follows. In subclause 1, delete the word had and insert the word has. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Honorable Senators, the question is that clause 65 as amended now stand part of the bill. Those in favor say aye.
You put in my amendment there?
No, he didn't. Senator Mark?
No, he rejected it.
I understand
but
he rejected it.
Right.
So I'm putting the amendment.
No, even if he rejected it, sir, that is the Honorable Attorney General. The Honorable Attorney General has rejected it, which I have no problem with. But we on this side saying we want it put to the vote. And we have a democratic right here to ensure that. I think that people are tired. And I think you're rushing to go to a public meeting in Barataria.
Senator Mark, enough.
Thank you, sir. So, but Mr. Chairman, could you kindly put my... You're a good baptism of fire. Boris, distinguished. The people's ambassador.
Okay, so what I'm, Senator Mark.
Yeah,
So I'm going to finish the AG's question and then put the question as amended by Senator Mark. So the question is that clause 65, once again, be amended as follows. In subclause 1, delete the word had and insert the word has. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Honorable Senators, the question is that clause 65 be amended as put forward by Senator Mark. Those in favor say aye.
Aye.
Those against say no.
No. A division, sir.
Mr. Khan.
No.
Ms. Gopi Schoon.
No.
Ms. Baptiste Primus.
No.
Mr. Rambrat.
No.
Mr. Sinanan.
No.
Mr. Kazim Hussein.
No.
Ms. West.
No.
Mr. LeHunt.
No.
Dr. Henry.
No.
Mr. Singh. Mr. Cummings. Mr. Dookie.
No.
Mr. Young.
No.
Mr. Boris.
No.
Mr. Thomas.
No.
Mr. Mark.
Yes.
Ms. Haynes.
Yes.
Ms. Amin.
Yes.
Mr. Saddam Hussein.
Yes.
Mr. Obika.
Yes.
Mr. Ramdeen.
Yes.
Mr. Richards.
No.
Ms. Chotesi.
Yes.
Mr. Vieira.
No.
Dr. Dial Singh.
No.
Ms. Diwan.
Abstain.
Ms. Sipasad.
Yes.
Mr. Timal.
No.
Mrs. Thompson-Nai.
No.
Dr. Dylan Remy.
No.
So it's 10. The results of the day.
Honorable Senators, the results of the division are as follows. 10 for, 19 against.
7, 22, 7, 4.
Honorable Senators, the results of the division are as follows. 7 for, 22 against, and 1 abstention. The clause is not amended.
Sorry, Mr. Chair, sorry, was there a yes or a no? I got Senator Choate as yes. Senator Sipasad said yes. No, no property retroactive.
Honorable Senators, in the interest of accuracy and proper record, we'll do the division again.
Mr. Khan.
No.
Ms. Gopi Schoon.
No.
Mrs. Baptiste Primus.
No.
Mr. Rambarat.
No.
Mr. Sinanan.
No.
Mr. Hussein.
No.
Ms. West.
No.
Mr. LeHunt.
No.
Dr. Henry.
No.
Mr. Singh.
No.
Mr. Cummings.
No.
Mr. Dookie.
No.
Mr. Young.
No.
Mr. Boris.
No.
Mr. Thomas.
No.
Mr. Mark.
Yes.
Ms. Haynes.
Yes.
Ms. Amin.
Yes.
Mr. Hussein.
Yes.
Mr. Obika.
Yes.
Mr. Ramdeen.
Yes.
Mr. Richards.
No.
Ms. Chote SC,
Yes.
Mr. Vieira,
No.
Dr. Dial Singh,
No.
Ms. Dionarain,
Abstain.
Ms. C. Prasad,
Yes.
Mr. Timal,
No.
Mrs. Thompson-Ai,
No.
Dr. Dylan Remy.
No.
Honorable Senators, the results of the division are as follows: 8 for, 21 against, and 1 abstention. The question that Clause 65 be amended as proposed by Senator Mark is not carried.
I know that the AG would want to make sure, and you and all of us, that whatever is agreed upon, the language is proper and it is consistent. So with that, if I can ask or crave your indulgence, sir, I'll ask the Attorney General to look at, once you grant me leave, sir, 65-9, where there is leave, you have been consistent and you put permission, and there's leave here. So I think that you want to be consistent and use the word permission. And on page 56, 10, subsection 10, it starts off with leave. Again, you'll want to put permission. And then in 10C, the last word in that sentence is leave again. I think you'll want to put permission for your consideration, Attorney General.
Mr. Chair, I draw a distinction between the previous occasion where we changed leave to permission, because here we're actually asking for a step prior to. So we want, in the normal aspects of what leave involves, for the rules to develop as to how you approach the court in this fashion. So we intend to use the word leave.
Okay, all right, cool.
Honorable Senators, the question is that Clause 65, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 65, as amended, now stands part of the bill. Honorable Senators, I think now is a good time to take the tea break. As a result, this House will now stand suspended until 10 to 6.